So last week I had a settlement on a case, and it wasn't the biggest settlement that I've had in my career, or even close, but still it was one of the most fulfilling settlements that I had because liability on the case of who was at fault was so hotly contested. And throughout the discovery process, I was able to prove that the defendants were at fault, which ultimately led to the insurance company caving in and making an appropriate offer on the case. So in this case, it was a motor vehicle case where both the plaintiff and the defendant were driving cars and they both had stop signs. The insurance company had been arguing that, oh, it's a 50-50 liability case. It should be split in half because we'll never be able to prove which plaintiff or defendant was at fault. So it was two stop signs, crash in the intersection, and I will show you a little bit about this crash and how I proved this case. Okay, so this is the actual intersection where this incident took place. Let me zoom in a little bit. And as you can see at this intersection, there's a stop sign for all ways of traffic, and it's a two-way street for each way. So in this case, the plaintiff, which I'm going to have in green, was coming from this direction and heading into the intersection that way. The defendant in this case was heading in this direction and heading into the intersection that way. Now, both the plaintiff and the defendant say that they stopped at the stop sign before entering the intersection. Now, the first thing we do in a case like this, which is a potential 50-50 liability case, is we look at the police accident report. And the accident report's important because a lot of the statements on the report, while the entire report is not necessarily admissible, there's certain statements on the report which are admissible. So, and it's important to look at these statements because these are statements that are given at the scene to the reporting police officer. So in this case, it says that the driver of vehicle 1, which is the plaintiff, states she was traveling northbound on 268th Street at 83rd Avenue when she stopped at the stop sign, proceeded through the intersection, and driver 2, the defendant, went through the stop sign and collided into her driver's side of her vehicle. It should be noted that it was not northbound, so that was a mistake on the police report. According to the defendant driver of vehicle 2, he states that he was traveling eastbound on 83rd Avenue, which he wasn't, it was westbound, at 268th Street when he stopped at the stop sign and vehicle 1 proceeded through the intersection at the same time, causing him the incident. Now, it's very interesting because when two vehicles enter the intersection at the same time, there's actually a section of the law, Vehicle and Traffic Law 1140, which addresses this exact point. And when two vehicles enter an intersection from different highways at approximately the same time, the driver on the vehicle of the left shall yield the right of way to the vehicle on the right. In this case, the driver of the vehicle on the left was the defendant, and the driver of the vehicle on the right was the plaintiff. So in accordance with VTL 1140, if the accident happened as the defendant stated on the police report, he should have been yielding to the other vehicle anyway, and he was at fault. Now, I made this argument to the court, but unfortunately, VTL 1140 was found persuasive, but not the authority in terms of who's at fault. So, what did we do next? You know, on the police report, which we looked at, there was no witnesses listed, and so that kind of concerned me. But what I did is I hired an investigator to perform something called a 911 sprint call report. Now, at the scene, my client involved with this incident called 911, and that's how the police officers arrived at the scene. But they weren't listed anywhere. So what we did is we hired an investigator to run something called a 911 sprint call report, and we came up with a phone number of the person that called 911. I called that person, and she remembered that, yes, She did go or remember the incident. She actually, believe it or not, she lived in this house right here. This happened early morning, and she had just had a newborn baby at the time and was sitting on the steps right here and had a direct view onto how the incident occurred. We sent her a subpoena for a deposition. She was cooperative, and she helped support the case that the defendant actually ran the stop sign, that he never stopped here, and that he ran into the plaintiff and contacted her on the right side. Now, this case was extremely rewarding because they had combated the liability so hard at the beginning of the case, and I told them that I'm going to prove that their insured was liable, and eventually was able to do that, but was not able to do that without putting in the hard work, doing my due diligence, making sure we check the 911 call records. So unless your attorney is going to go out there, spend the money on these things, turn over every rock to make sure that you have all the facts, you might have accepted, or other attorneys might have accepted, a 50-50 liability split in this case, and the case potentially could have settled for half of the amount of the actual value of the case. Here, it was so gratifying because I did my job, it paid off, and it ended up in a very nice recovery for the client.